This is Kathy Knipfer, instructor for Nursing 2333, recording the Managing Nursing Care lecture for Chapter 5, Legal and Ethical Issues. The Nurse Practice Acts affect all facets of nursing practice and are the law within a given state or U.S. territory. They define three categories of nurses: licensed practical or vocational nurses, licensed registered nurses, and advanced practice nurses. The Nurse Practice Acts set the educational and examination requirements for their respective state. The Nurse Practice Act establishes a state board of nursing, which develops and implements rules and regulations. The Act defines the function of each category of nurse, and it must be read to understand allowable actions for each of the categories. The main purpose of the state boards of nursing are to ensure enforcement of the Act, regulating those practitioners who come under its provisions, and preventing individuals not addressed within the Act from practicing nursing, as well as protecting the public, ensuring that those who present themselves as nurses are licensed to practice within the state. Multiple states are now a part of the Nurse License Compact. RNs may be licensed in one state and practice in another state within the compact. Generally, this is seen in conjunction with telenursing and the use of telecommunications technology, but it also may be seen with nurses who live close to state borders and they travel to adjoining states for employment. The state where the patient or client resides is the state that regulates the nurse's practice. Negligence and malpractice. Negligence denotes conduct that is lacking in care and typically concerns non-professionals. It equates with carelessness. Malpractice, or otherwise known as professional negligence, concerns professional actions. It's the failure of a person with professional education and skills to act in a reasonable and prudent manner. Common causes of malpractice or negligence among nurses include the failure to follow the standards of care, communicating appropriately, accessing and monitoring patients, and acting as a patient advocate. Both result either from commission or omission, and both are non-intentional. Though the patient suffers some harm, there was never an intent for this to happen. Elements of malpractice include a duty owed to the patient, a breach of this duty owed to the patient, foreseeability, causation, injury, and damages. And we'll talk about each of those in subsequent slides. Duty owed to the patient. It's easy to show that a duty is owed to the patient, and it's generally established through a valid employment contract with the healthcare facility. The level to which the duty is owed is harder to show, and is based on standards of care, which are the minimum required actions. Standards are set by institutional policy and procedure manuals, job descriptions, level of education and experience, professional organizations such as the American Nurses Association, and specialty nursing organizations, and also accreditation standards. Nurse managers must ensure that standards are known and followed and updated as needed. Breach of duty owed to the patient. This is synonymous with failing to uphold the standard of care owed to the patient. To determine the appropriate standard of care that should be applied, expert witnesses give testimony in court on a case-by-case basis. This helps the judge and jury to understand the nursing standards of care. Nurses would serve as the expert witnesses in nursing malpractice cases. Expert opinions attesting to the standard of care may differ depending on whether the injured party is trying to establish the standard of care or whether the defendant nurse's attorney is establishing an acceptable standard of care for the given circumstances. The injured party will attempt to show that the acceptable standard of care is at a much higher level than that shown by the defendant hospital and staff. Foreseeability is the concept that certain events may reasonably be expected to cause specific results. This is based on education and prior knowledge. So failing to meet the standard of care may result in harm. For example, omitting a previously ordered medication, such as an oral hypoglycemic medication, could result in patient harm from hyperglycemia, or failure to assist a patient known to be at high risk for falls could result in the patient falling and breaking a hip. Foreseeability is necessary because the resulting injury was not intentional. Thus, the practitioner must know beforehand the type of injury that could occur from an omitted medication or failure to safeguard the patient. Common areas of potential liability include medication errors, patient falls, and failure to enact physician orders. Causation and injury. What the nurse did or failed to do must directly cause the patient's subsequent harm. There must be a direct relationship between the failure to meet the standard of care and the patient's injury. It is not sufficient that the standard of care has been breached, but rather that the breach of the standard of care must be the direct cause and effect factor for the injury. The harm or injury that occurs must be physical for malpractice to be found against the healthcare provider. Pain and suffering are allowable harms when they accompany a physical injury. Although there are some specific exceptions to the requirements that a physical injury must result, they are extremely limited and usually involve specific relationships, such as the parent-child relationship. Damages. The patient must be able to prove injury so that damages may be assessed. The purpose of damages is to compensate the injured party for the harm that was done. Thus, immediate and future medical costs can be assessed. The patient must show financial harm before the courts will allow a finding of liability against the defendant and/or the hospital. To prevent malpractice lawsuits, the nurse manager should ensure that employees meet or exceed the standard of care. The nurse manager should review standards periodically so that standards can be revised. The nurse manager should also review randomly selected patient records for evidence that standards are being met. The nurse manager should also perform scheduled evaluations of staff and inquire and ask employees what constitutes the standard of care and where they would find the standard of care in the institution. Personal liability defines each person's responsibility and accountability for individual actions or omissions. Even if others can be shown to be liable for a patient injury, each individual still retains personal accountability for his or her actions. The law, though, sometimes allows other parties to be liable for certain causes of negligence. This is known as vicarious liability or substituted liability. The doctrine of respondent superior, which means let the master know, makes employers accountable for the negligence of their employees. Corporate liability is a newer trend in the law and essentially holds that the institution has the responsibility and accountability for maintaining an environment that ensures quality healthcare delivery for consumers. Corporate liability issues include things like negligent hiring and firing issues, failure to maintain safety in the physical environment, and providing a lack of qualified, competent, and adequate staff. Malpractice concerns for nurse managers include assignment, delegation, and supervision, duty to orient, educate, and evaluate, failure to warn, staffing issues, as well as protective and reporting laws. Now let's review assignment, delegation, and supervision. Supervision is the active process of directing, guiding, and influencing the outcome of an individual's performance of an activity. Delegation is the transfer of responsibility, but not of accountability, for the performance of an activity. Assignment is the transfer of the responsibility and the accountability for the performance of an activity. The nurse manager retains personal liability for the reasonable exercise of assignment, delegation, and supervision activities. The failure to assign, delegate, and supervise within acceptable standards of professional nursing practice may constitute malpractice. Delegation is most often encountered when working with unlicensed assistive personnel. Assignment typically occurs between professional staff members, such as when the nurse manager assigns patient care responsibilities to other professional nurses working in the same unit of the institution or community healthcare setting. The level of accountability for the nurse manager who assigns, as opposed to delegates, is fairly obvious, although there can be some accountability in both instances. If it can be shown that the nurse manager assigned or delegated tasks appropriately and had no reason to believe that the nurse to whom tasks were assigned or delegated was not competent to perform the task, the nurse manager potentially has either no or minimal personal liability. The converse is also true. If it can be shown that the nurse manager was aware of incompetence in a given employee, or that the assigned or delegated task was outside of their capabilities, the nurse manager becomes substantially liable for any subsequent injury to the patient. There is also a duty to orient, educate, and evaluate. Nurse managers are responsible for the daily evaluation of safe and competent nursing care delivery. This duty goes beyond that of the continuing education department. Nurse managers must ensure that those that they supervise continually provide safe and competent nursing care. The key is reasonableness and should be determined on a case-by-case basis. Remember to respond to any allegations of incompetent or questionable nursing care. Implement means of helping staff members gain the needed skills or education to ensure competent care, and follow up as needed to ensure that the staff member has mastered the skill or has the needed information on which to base future nursing care. Failure to warn involves warning subsequent potential employers of staff incompetencies or impairment. If the institution has sufficient information or suspicion to warrant the discharge of an employee or force a resignation, subsequent employers should be advised of those issues. The State Board of Nursing or agency that oversees disciplinary actions of professional and non-professional nursing staff should also be notified whenever there is a cause to dismiss an employee for incompetency or impairment, unless the employee voluntarily enters a peer assistance program. Most states now recognize qualified privilege and allow previous employers to give factual, objective information to subsequent employers. However, you should note that the previous employee must have listed the nurse manager or institution as a reference before this privilege arises. So nurses and nurse managers should check the individual state law before discussing qualified privilege. There are three areas to consider regarding staffing issues. The first is maintaining an adequate number of staff. The second is floating staff from unit to unit. The third is using temporary staff to augment current staff numbers. To maintain adequate staff, The nurse manager should follow accreditation standards that mandate adequate staffing with qualified personnel. This applies to both numbers of staff as well as the staffing mix. Adequate staffing is based on the number of patients, care acuity scores, as well as numbers and classification of the nursing staff. California was the first state to adopt legislation that mandated a fixed nurse to patient ratio, and this was in 1999. 15 states plus the District of Columbia have passed safe staffing measures rather than mandating ratios. These measures usually call for a committee to develop, oversee, and evaluate a plan for each specific nursing unit and shift based on patient care needs, appropriate skill mix of RNs and other personnel, the physical layout of the unit, as well as the national standards or recommendations regarding nursing staffing. To prevent nurse managers' liability, they must show that sufficient numbers of competent staff were available to meet nursing needs. The guidelines for staffing. Nurse managers in times of inadequate staffing should alert agency administration of the concern. They should reassign staff as appropriate, approve overtime for adequate coverage, and restrict new admissions. Nurse managers have a legal duty to notify administration, either directly or indirectly, when understaffing endangers patient welfare. Once the nurse manager can show that he or she acted appropriately, used sound judgment given the circumstances, and alerted his or her supervisors of the serious nature of the situation, the institution and not the nurse manager becomes potentially liable for staffing issues. Floating staff to alternate units is one means to ensure that every area of the facility is adequately staffed. The manager should consider staff expertise, patient care delivery systems, and patient care requirements before deciding which staff to float. Staff should be cross-trained during times of adequate staffing. Nurses could be familiar with 2 or 3 areas so that they can competently float to other areas. Nurses should be floated to units as similar to their own unit as possible. This requires the nurse manager to match the nurse's home unit and float unit as much as possible, or to consider negotiating with another nurse manager to cross-float a nurse. Open communication regarding staff limitations and concerns, as well as creative solutions for staffing, can alleviate some of the potential liability involved and create better morale among the floating nurses. Agency or temporary staff. This has become more important because of the principle of apparent agency. This has created increased liability concerns among nurse managers. Courts have begun to hold the institution liable under the principle of apparent agency. This refers to the doctrine whereby a principal becomes accountable for the actions of his or her agent. Apparent agency is created when a person or agent holds himself or herself out as acting in behalf of the principal. This principle applies when it can be shown that a reasonable patient believed that the healthcare worker was an employee of the institution. If it appears to the reasonable patient that this worker is an employee of the institution, the law will consider the worker an employee for the purposes of corporate and vicarious liability. These trends make it imperative that nurse managers consider the temporary worker's skills, competencies, and knowledge when delegating tasks and supervising the worker's actions. Protective and reporting laws. Nurse managers are often the individuals who are responsible for ensuring that the correct information is reported to the correct agencies, thus avoiding potential liability against the institution. Many states now also have mandatory reporting of incompetent practice, especially through Nurse Practice Acts, Medical Practice Acts, and the National Practitioner Data Bank. Mandatory reporting of incompetent practitioners is a complex process involving both legal and ethical concerns. Examples of other items that should be reported are suspected child or elder abuse or certain categories of diseases or injuries. It's important that the nurse manager knows what the law requires, when reporting is mandated, who the report should be sent to, and what the individual institution expects of its nurse managers. And when in doubt, seek clarification from the State Board of Nursing, hospital administration, or a professional organization. Informed consent is the authorization by the patient or the patient's legal representative to do something to the patient. It's based on legal capacity, voluntary action, and comprehension. Legal capacity, the first requirement, is determined by age and competency. The age is generally 18, and competency involves the ability to understand the consequences of actions or the ability to handle one's personal affairs. State statutes mandate who can serve as the representative for a minor or an incompetent adult. The following types of minors may be able to give valid informed consent. Examples would be emancipated minors, minors seeking treatment for substance abuse or communicable diseases, and also pregnant minors. The second requirement, voluntary action, means that the patient was not coerced by fraud, duress, deceit into allowing the procedure or treatment. The third requirement, which is comprehension and the most difficult to ascertain, states that the patient must be given sufficient information in terms he or she can reasonably be expected to comprehend to make that informed choice. Inherent in this doctrine of informed consent is the right of the patient to give informed refusal. The patient must clearly understand the possible consequences of their refusal. Now we'll review some selected informed consent issues. Research issues are impacted by the federally enacted HIPAA laws. The HIPAA law of 1996 has affected how medical record information can now be used in research studies. Research issues vary in regard to de-identified information and protected health information. De-identified information is health information that cannot be linked to an individual. Most of the 18 demographic items constituting the protected health information, or PHI, must be removed before researchers are permitted to use patient records without obtaining the individual patient's permission to use or disclose the PHI. Concerns over the past abuses that have occurred in the area of research with children have led to the adoption of federal guidelines specifically designed to protect children when they are enrolled as research subjects. Before proceeding under these specific guidelines, state and local laws must be reviewed for laws regulating research on human subjects. A final issue with informed consent about which nurse managers should be cognizant is health literacy, or the degree to which individuals have the capacity to obtain, process, and understand basic health information, including services needed to make appropriate health decisions. Functional health literacy relates to the person's ability to act upon the basic health information received. Privacy and confidentiality. Privacy is the patient's right to protection against unreasonable interference with reputation or right to be left alone. Confidentiality is the right to privacy of the medical record. Within a medical context, the law recognizes the patient's right to protection against appropriate appropriation of the patient's name or picture for the institution's sole advantage, intrusion by the institution on the patient's seclusion or affairs, publication of facts that place the patient in a false light, and public disclosure of private facts about the patient by the hospital or staff. Institutions can reduce potential liability in this area by allowing access to patient data, either written or oral, only to those who have a need to know. The nurse manager should ensure that staff members both understand and abide by rules regarding patient privacy and confidentiality. Interesting patients should not be discussed with others, and all information concerning patients should be given only in private and secluded areas. The patient's right of access to his or her medical record is another confidentiality issue. Although the patient has a right of access, individual states mandate when this right applies. Incident reports serve to alert the facility to risk management and quality assurance issues. They are considered internal documents, and thus they are not discoverable or open for review by injured parties or attorneys representing injured parties. In most jurisdictions, though, the courts have held that the incident report was discoverable and thus open to review by both sides. It is prudent for nurse managers to complete and to have staff members complete incident reports as though they will be open records, so they should avoid language of liability. It is also inadvisable to make any notation of the incident report in the official patient record, because such a notation incorporates the incident report by reference, and then there is no way to keep the record from being seen by the injured parties or attorneys for the injured parties. Nurse managers need to be familiar with employment laws. The ones they need to be familiar with include the Equal Employment Opportunity Laws, Americans with Disabilities Act of 1990, Occupational Health and Safety Laws, Family and Medical Leave Act of 1993, as well as whistleblower laws. Equal employment opportunity laws prohibit discrimination based on gender, age, race, religion, handicap, pregnancy, and national origin. Title VII of the amended Civil Rights Act of 1964 governs these equal employment opportunities. The amended Civil Rights Act of 1991 governs sexual harassment in the workplace. The Americans with Disabilities Act of 1990 provides protection to persons with disabilities. Disability is defined as physical or mental impairment that substantially limits one or more of the major life activities of an individual. The fact that there is a record of such impairment to the individual is regarded as establishing that the individual has the impairment. The purpose of the ADA, or Americans with Disabilities Act, is to provide a clear and comprehensive national mandate for the elimination of discrimination against individuals with disabilities, and to provide clear, strong, and consistent enforceable standards addressing discrimination in the workplace. It's closely related to the Civil Rights Act of 1991 and incorporates anti-discrimination principles established in Section 504 of the Rehabilitation Act of 1973. The overall effect of the ADA is that persons with disabilities will not be excluded from job opportunities or adversely affected in any aspect of employment unless they are not qualified or are otherwise unable to perform the job. The ADA requires an employer or potential employer to make reasonable accommodations to employ persons with a disability. The law does not mandate that individuals with a disability be hired before fully qualified persons who do not have a disability. It does mandate that those with disabilities not be disqualified merely because of an easily accommodated disability. Essential job functions are defined by the ADA as that the person must be able to perform to be qualified for the employment position. The Occupational Safety and Health Act ensures that healthful and safe working conditions exist in the workplace setting. Among other provisions, the law requires isolation procedures, placarding areas containing ionizing radiation, proper grounding of electrical equipment, protective storage of flammable and combustible liquids, and the gloving of all personnel when handling bodily fluids. Newer aspects that the rules address include violence and bullying in the workplace, safe patient handling, as well as ergonomic issues that are common in the healthcare industry. Violence is perhaps the greatest hidden health and safety threat in the workplace today, and nurses, as the largest group of healthcare professionals, are most at risk of assault at work. The American Nurses Association reported a significant number of back injuries related to handling of patients. They're promoting legislation that would require hospitals and other healthcare institutions to develop programs that prevent work related musculoskeletal disorders and eliminate manual patient lifting. OSHA has had initiatives that focus on the workplace hazards that are most common in the healthcare industry, and this includes ergonomic stressors related to patient lifting. The Family and Medical Leave Act of 1993 balances the demands of the workplace with the demands of the family, allowing employed individuals to take leaves for medical reasons. This includes care for the birth or adoption of a child, care of a spouse, child, or parent with serious health problems, and health care needs of the employed individual himself or herself. The Act was passed because of the large numbers of single parent and two parent households in which the single parent or both parents are employed full time, and this places job security and parenting at odds. The Act is gender neutral and allows both men and women the same leave provisions. To be eligible under the Act, the employee must have worked for at least 12 months and worked at least 1,250 hours during the preceding 12-month period. The employee may take up to 12 weeks of unpaid leave. An amendment was signed in 2008 that permits a spouse, son, daughter, parent, or next of kin to take up to 26 work weeks of leave to care for a member of the armed forces, including a member of the National Guard or Reserves, who is undergoing medical treatment, recuperation, or therapy, is otherwise in outpatient status, or is otherwise on the temporary disability retired list for a serious injury or illness. Whistleblower laws were enacted to protect healthcare professionals who are terminated in retaliation for speaking out against unsafe practices, reporting violations of federal laws, or filing lawsuits against employers. The best known case is the Winkler County Nurses Lawsuit, and you should look that up on the internet. Essentially, whistleblower laws state that no employer can discharge, threaten, or discriminate against an employee regarding compensation, terms, conditions, location, or privileges of employment because the employee in good faith reported or caused to be reported, either verbally or in writing, what the employee had reasonable cause to believe was a violation of state or federal law, rule, or regulation. Most whistleblowers are internal, that is, they report misconduct to a fellow employee or supervisor within the agency. External whistleblowers are those who report misconduct to outside persons or entities. The Winkler County Nurses Lawsuit included violations of the nurses' rights of free speech and due process, whistleblower retaliation, and interference with their business relationship, specifically their employment status. Ethics concern the individual within society and the why of actions as opposed to what was done or not done. Ethics provide no right or wrong answers, rather, there are better or less desirable actions. Ethics is often encountered in conjunction with legal concerns. An example would be the Teresa Schiavo case. The nurse manager must be cognizant of both laws and ethics in everyday management concerns, remembering that ethical principles form the essential base of knowledge from which to proceed, rather than giving easy, straightforward answers. And I will provide you with a handout on the Teresa Schiavo case so that you can identify the legal and ethical concerns. There are 8 ethical principles that guide healthcare workers. The first is autonomy or personal freedom. It's the right to choose what will happen to oneself, as well as the accountability for making individual choices. Beneficence is the duty to do good. It is the basic obligation to assist others. Veracity or truth telling demands that the whole truth be told and in terms that the individual can be expected to understand. Justice or fairness is the principle of treating all persons equally and fairly. Paternalism is assisting with decision making. It may be used to assist persons to make decisions when they do not have sufficient data or expertise. Paternalism becomes undesirable when the entire decision is taken from the individual. Fidelity means keeping one's promises or commitments. Respect for others acknowledges the right of individuals to make decisions and to live by their decisions. Respect for others also transcends cultural differences, gender issues, and racial concerns, and it's the first principle enumerated in the ANA Code of Ethics for Nurses. Professional codes of ethics are formal statements that articulate values and beliefs of a given profession. They serve the following functions. They inform the public of the minimum standards of conduct for members of the profession. They outline ethical considerations of the profession. They provide guidelines for ethical practice by members of the profession and guide the discipline's self-regulation. The Code of Ethics for Nurses, published by the American Nurses Association, should be the starting point for any nurse faced with an ethical issue. It's a 9-point code that guides nurses in understanding the extent of their commitment to the patient, themselves, other nurses, and the nursing profession. Nurses and their nurse managers should ensure that the provision of the code are incorporated into nursing care delivery in all clinical settings. Along with establishing the ethical standard for disciplines, the Nursing Code of Ethics provide a basis for ethical analysis and decision making. Moral distress occurs when the individual is faced with situations in which two ethical principles compete. It is experienced in clinical settings when nurses cannot provide what they perceive as the best care or outcome for a given patient. Examples include disagreements regarding patient interventions and limited patient care resources. Examples of moral distress include constraints caused by financial pressures, again, the limited patient care resources, disagreements among family members regarding patient interventions, and or limitations imposed by primary health care providers. The impact of moral distress can be serious. Research has shown that there is evidence that moral distress compromises patient care and that moral distress may be manifested in such behaviors as avoiding or withdrawing from the patient care situations. Additional behaviors include failure to act as a patient advocate, which often further contributes to patient discomfort and suffering. The ethics committees provide long and short-term assistance by providing structure and guidelines for potential problems. They serve as open forums for discussion. They function as patient advocates by placing the patient at the core of the committee discussions. With the increasing number of ethical dilemmas in patient situations and administrative decisions, healthcare providers are increasingly turning to hospital ethics committees for guidance. In most settings, the ethics committee already exists because there are complex issues dividing healthcare workers. An alternative to ethics committees is to use ethical grand rounds. This allows staff members who may later become involved in ethical decision making to begin reviewing all the issues and to become more comfortable with ethical issues and their resolution. There may be future ethical issues to consider, such as development of nurses as leaders in the healthcare delivery, the rights of patients to refuse healthcare interventions, and the ability of patient advocates in today's healthcare structure. There may be others. They could be issues surrounding death and dying, including the issues of hydration and nutrition for patients who are in a persistent vegetative state, and the ability to perform competent quality nursing care in a system that continuously rewards cost-saving measures rather than quality healthcare delivery, and that employs increasingly fewer professional nurses. As with ethical grand rounds, being aware of the issues and beginning to evaluate possible solutions will help nurses to better face ethical issues as they arise. Tips for incorporating legal and ethical issues. In conclusion, read and comply with provisions of the State Nurse Practice Act. Apply legal concepts in all healthcare settings. Understand and abide by state and federal employment laws. Implement the provisions of the Code of Ethics. And if legal and ethical issues are contradictory, legal aspects take precedence. Legal and ethical issues are difficult for all nurses. They are even more difficult for nurse managers because the nurse managers must also provide the leadership and be consultants for staff members regarding these complex issues. Remember that there are no right and wrong answers in ethical situations, merely better or worse solutions. Consider all aspects and consult with others before proceeding if there are unanswered questions.